Thank you, Celia. And thank you all, and good afternoon. Thank you for joining us on Zoom and on YouTube. And I want to say a special welcome to my fellow panelists, three persons for whom I have great respect and admiration in their respective influence on which they've had on my career. The Honorable Justice Andrew Burgess, Judge of the Caribbean Court of Justice, the guru of Commonwealth Company Law, who was the first person that piqued my interest in this area of law and inspired so many of us to think higher, broader, and deeper as my lecturer and my first boss when he was Dean of the Faculty of Law, UWI Cave Hill, Barbados. The Honorable Justice C. Dennis Morrison, President of the Court of Appeal, who I first met at the Norman Manley Law School and who brought life to the law of evidence, presented me at the bar, and subsequently became my second boss at Dulcox. Justice Morrison, thank you for all the years of unwavering support and for the gracious forward to the book. You are a scholar and a gentleman. Professor Poonam Puri, Professor of Law, Osgoode Hall Law School, York University, Canada, whose work I've cited on more occasions than I can count, and who is the boss in this area of law. I'm grateful for the time you took to meet with me in Toronto some 10 years ago at a cafe on Eglinton, or was it Davenport? Not sure. One of those stations over 10 years ago. And it has been an honor to have you share your knowledge in my LLM course and vice versa, and to generously give of your time and experience. I look forward to continuing to work with you. Some of you may be acquainted with the recent social media meme challenge, how it started, how it's going. This is where persons show, for example, a picture of themselves, either pregnant or with newborn twins, and then you see the child, another picture, the child grown, how it's going, what's going on right now, and them as old and maybe a little fatter. Or you'll see a couple on a first date at their wedding, and then the current situation with, say, 3 children and a house and chaos. This more or less sums up the publication. It is a survey of the Jamaica Companies Act when it was first introduced 15 years ago, and the current status of the provisions and how the jurisprudence is evolving. Jamaica was much later than most Commonwealth Caribbean jurisdictions in introducing new companies legislation. And unlike most Commonwealth Caribbean territories, adopted the Canadian model while retaining some of the old UK provisions and creating new provisions. I like to refer to it as a hybrid. This unique approach to law reform in this area of the law has created challenges and opportunities. The challenges include the lack of precedent and in some areas anomalies in the law. I see Justice Burgess looking at me. While the opportunities may be found where the practitioners decide amongst themselves how to interpret the law. This publication took much longer than anticipated. This was mainly due to the fact that chapters had to be rewritten or deleted given the changes in the law over the last 10 years. In fact, one version of the publication was heading to press when significant legislation was passed and the publication had to be pulled. I will refer to these changes under the various headings. The Companies Act 2004 was introduced to modernize company law and to create an investor-friendly regime. The change from a contractual model to a regulatory model consistent with the Canadian and other Commonwealth territories. Unfortunately, however, the provision as to the contractual relationship between the company and the shareholders, shareholders and the company and the shareholders amongst themselves, under the old UK position has survived the revision in the Act, and as a result has created somewhat of an anomaly in Jamaica. In addition, the shareholder primacy model of old has been replaced by a broader stakeholder model. It is arguable, however, that Jamaica is more limited in this regard. Incorporation. I'm going to go through now just some headings so that you get a sense of how I approached the book. I looked at some subheadings broadly and then focused on the changes in the law and then, of course, the more recent changes. So incorporation, we all know that we had moved from the old position of having several persons to form a company. We are using one corporate constitution and so on. As recent as 2013, however, Jamaica also introduced a single business registration form to facilitate registration under relevant laws. In the area of equity financing, there have also been recent changes, as recent as 2017, consistent with the demand for greater transparency, accountability, and good governance to require information in relation to beneficial ownership information for foreign companies with central management in Jamaica, the prohibition on issuance of share warrants, and a retention period for records of the company. This, of course, was instituted because of the pressures internationally to have more transparency in our laws. And of course, our multilaterals insisted that these provisions be included to ensure good governance. And of course, to encourage foreign direct investment. In the area of debt financing, Jamaica introduced the Security Interests in Personal Property Act, and that was in 2013. And this had the effect of removing the distinction between floating and fixed charges and the requirement for registration through the Electronic Securities Registry. This is also an interesting development because we now have a shift from having the traditional security interests to that of security interests in personal property. Again, it was really coming out of our multilaterals to try and encourage investment, especially for small businesses. The success of that remains to be seen. In terms of corporate management, where corporate management is concerned, Jamaica is unique in having adopted the concept of shadow director, which is found in the UK legislation, and has given rise to much litigation as to the interpretation of the description as to who is a shadow director. There has been much litigation trying to reconcile de facto with shadow directors and giving us some idea of what criteria we should look for. In addition, the Jamaican courts have yet to consider whether all duties and responsibilities of directors apply to shadow directors, as in the UK, or just where the concept is referred to in the Act. So the dilemma we have is that if you look at our Hansard, you will find that we discuss this in the context of the provisions in the Companies Act. However, there is a broader consideration, and that is whether all provisions that relate to directors ought to apply to shadow directors, as it does in the UK. Other challenges in the area of corporate management relate to the inclusion of a range of defenses to the duty of care, diligence, and skill of directors and officers. This is unique to Jamaica, where we introduced a number of due diligence defenses. We had the benefit, however, of Canadian legislation as it evolved, because we started much later than most Commonwealth territories, and indeed Commonwealth Caribbean territories. But we added some as well, and so we are particularly unique in that area. More recently, in 2017, we have added an additional fiduciary duty. But that duty is only directed to directors, and it is a duty to avoid a conflict of duty and interest. So this is an addition to the duty not to have a conflict of duty and interest, which traditionally is cured by, in my words, disclosure. And this new provision, however, is at odds with the traditional duty not to have a conflict of duty and interest in the way in which it is worded. Again, it remains to be seen how the courts will treat with this. And I dare say it is an awesome duty, although it may be found at common law in Canada, for example, under the People's Case. As mentioned earlier, most Commonwealth territories have adopted the stakeholder theory, which is clear from the requirement that directors and officers must take into account the interests of a broad range of stakeholders. And by allowing specific stakeholders to bring actions either on behalf of the company through derivative actions or on behalf of themselves through the oppression remedy. Directors and officers in Jamaica, however, may take into account stakeholder interest, but are not required to do so. Again, it remains to be seen how that will affect the aim of advancing the stakeholder theory. The provisions relating to the oppression remedy in Jamaica have been much more restrictive than the provisions found in other Commonwealth Caribbean territories by limiting the class of complainants and having a victim class in Jamaica wider than that of the complainant class. The wider Commonwealth Caribbean courts have had to deal with the dilemma of having a wider complainant class than a victim class. It remains to be seen again how Jamaican courts will treat with the flip side of our own dilemma. It is notable, however, that recently, 2017, the Jamaica Companies Act was amended to include unfair disregard of the interests of any member of the victim class, along with oppression and unfair prejudice. So to be clear, most of the Commonwealth and Canada, of course, following Canada, and most of the Commonwealth Caribbean had grounds for an oppression remedy founded in oppression, unfair prejudice, or unfair disregard of their interests. Jamaica was lacking in the latter, and we have now introduced it. So that's a welcome introduction or addition. The most notable piece of legislation which has impacted the Companies Act, and I have to mention here, and my publication by wiping out an entire chapter, but there you have it, it's a good thing, was the introduction of the Insolvency Act 2014. The Companies Act no longer applies to winding up of insolvent companies. One possible anomaly is the provision relating to application by members of the company to have the company wound up on just and equitable grounds. This section has survived the old act and is in our new act. And it appears to be redundant in that the same, I submit, may be achieved under the oppression remedy. The Jamaica Companies Act is a unique piece of legislation. Given its hybrid nature and the way it started, is different in many respects from the way it is now. Indeed, the same can be said for the Commonwealth Caribbean and Canada, on which much of the law is based. I look forward to the comments of my colleagues on the way it is going. Before I hand over to the Honorable Justice Andrew Burgess, Judge of the CCJ, I would like to express my gratitude first to God for preserving me and allowing me to finish this book finally. My husband and my family, my parents who have always said, you can do this, for the support, my colleagues at the Faculty of Law, and to the student researchers. It took so long, they're now all accomplished attorneys in their own right. And they were all on this journey with me. And of course, the publishers, Caribbean Law Publishing, for their patience and the pulling and the bringing back and the pulling and the bringing back of the book. I now hand over to Justice Burgess. Thank you for your time.
Let me see, just sharing the screen. I'll have to abandon that. Thank you very much, Suzanne. Fellow panelists, ladies and gentlemen, let me begin by saying what a privilege and honor it is for me to be invited to participate in the launch of this superb book authored by my perennial friend and colleague, Suzanne. I had the good fortune to be the leader of Suzanne's tutorial in company law at the Faculty of Law, Cave campus. It is there that I was first exposed to Suzanne's uncommon gift of rigorous legal analysis and argumentation in this subject, the company law. I am therefore not in the least surprised her commendable work in this subject, which has culminated in the present book. Warmest congratulations, Suzanne, and we celebrate this occasion with you. I've chosen as the topic of this short presentation, new companies legislation in Commonwealth Caribbean courts. I've chosen this topic because I think it will afford a useful backcloth against which to appreciate Suzanne's work. Put simply, recent regional companies legislation has its foundation in Canadian legislative provisions, as Suzanne was just pointing out. These provisions are new and distinct, both in character and purpose, in the context of the regional company law regime. Inevitably, therefore, as Suzanne has already pointed out, a challenge arises in relating these recent provisions to the existing body of law governing companies in the region. Now, my reach, as you will notice, is a little wider than Suzanne. Suzanne is, her book is intended to deal with the challenges in the context of the Jamaican Companies Act and the amendments to the Jamaican Companies Act. But I believe that if I give a little bit more involved background to the companies legislation, development of company law in the region, you will be afforded a better opportunity of understanding the magnitude of the challenge which confronted Suzanne in this work and her earlier work as well, because she has two excellent publications in company law. So let me start by giving a brief background to the new legislation. And I will begin by looking at the roots of company law in the Commonwealth Caribbean, including Jamaica. Now, in this regard, I think it is important to remember that Commonwealth Caribbean company law has its origins in English legislative and case law developments. English company legislation was introduced into the region by regional legislatures adopting and repeating the provisions of one English Companies Act or another. In the meantime, English company case law developments were introduced with the adoption of the legislation on the general principles governing the authority of English judicial precedents on adopted English legislation. In England itself, the company as a legal construct grew out of 5 major pieces of legislation, beginning in 1848 with the Joint Stock Companies Act and culminated in 1948 with the 1948 Companies Act. But the 2 English acts which were most influential in the West Indies, in the Commonwealth Caribbean, were the 1862 Act, Companies Act in England. And this act was adopted in Jamaica, for instance, was adopted in the other territories, the Windward and Leeward Islands, back in the 1880s, and it was adopted in Jamaica in 1884. I'm sorry, in 1886. This act in Jamaica, the 1882 Act, continued to be the law in Jamaica up until 2004. Of course, there were amendments along the way, including amendments to bring the act up to date in terms of the 1948 English Companies Act. In the other territories, the other act, English Act, which was of greatest significance, was the English Companies Consolidated Act of 1908. And this act found its way into Barbados in 1910 and into Grenada in 1927 and so on. But the critical thing that you need to remember is that this act, these 2 acts, the 1862 Act and the 1908 Act, remain in place, except for a couple of amendments, up until the Canadian model was enacted in the various territories. Now, I think that we could benefit a little from a little insight into how the Canadian model came to be introduced into the Commonwealth Caribbean. As we've seen, historically, the inspiration for company legislation in the region has been English legislative developments. In the last 25 years or so, however, this has changed dramatically. I think Suzanne has already adverted to it in her earlier presentation. But the major impetus for this change throughout the region occurred in March 1971, when the 8th meeting of the Council of Ministers of the Caribbean Free Trade Association launched a project for the harmonization of company law within member territories. That Council of Ministers meeting mandated that steps be taken to achieve the harmonization of company law in the Commonwealth Caribbean. A working party was appointed by the Secretary General, and a model draft Companies Act was prepared in 1978. Following this report and the draft model act, most territories in the region have passed new Companies Act. It started in 1982 with the Barbados Companies Act, and the Barbadian Act benefited from the Working Party report and the Model Draft Act. And both of these were heavily influenced by the Dickerson report of 1971 from Canada and the draft Canada Business Corporations Act. The Barbados Act was updated in the 1990s by the Caribbean Law Institute and presented to the region as the Caribbean Law Institute Model Act. And most territories in the Commonwealth adopted after in the 1990s, most territories in the Commonwealth Caribbean adopted the Caribbean Law Institute model. Trinidad in 1995, Montserrat in 1998, and so on. And as Suzanne earlier pointed out, Jamaica was the last to adopt the new legislation in the region, and it did so in 2004. The new Companies Acts in the region introduced a number of radical changes. And if I could just quickly point to the most important of these changes involved the removal of the distinction between private and public companies, a new constituent document, as Suzanne earlier pointed out, articles of incorporation were introduced in place of memorandum and of association and articles of association, which existed under the old law. There was the abolition of the ultra-vires doctrine and the constructive notice doctrine. These were abolished, and companies were invested with the capacity of an individual. The number of provisions on pre-incorporation contracts, they were also included, and the substitution of no par value shares for par value shares, that was introduced as well. And finally, the new legislation introduced detailed statutory rules for dealing with share capital, including extensive provisions for permitted capital reduction. Now, these were some of the changes which were introduced, but perhaps the most important change that was introduced, I think Suzanne made some reference to it, was what was called the complainant's remedy. And the complainant's remedy consists of two remedies: the oppression remedy and the derivative action. Now, so how have the courts in the Commonwealth Caribbean confronted the jurisprudential challenges posed by these new innovations? Now, to date, there have been about 50 cases decided in the Commonwealth Caribbean courts on the new legislation. In this regard, cases have arisen before the courts on a range of topics, including breach of directors' duties, separate legal personality, corporate capacity, share issue, and the complainant's derivative and oppression remedies. Of course, it would be impossible and perhaps not very profitable to attempt to present an analysis of each of these cases in turn in the time which is allotted to me. What I propose to do, therefore, is to identify and examine to a certain extent the major tendencies in the court's general approach to the interpretation and application of the new legislation. And in this way, I hope to provide a conspectus of the court's approach to the new legislation. Now, the first thing which I find most noteworthy about the court's approach to the new legislation is that there has been an unmistakable shift in these courts to placing considerable reliance on Canadian precedents. This is perhaps not surprising given the influence of Canadian Business Corporation Act on modern Commonwealth company legislation. This approach to invoking Canadian cases appears for the first time as far as my research is revealed, in a Barbadian case, the case of Canvas International and Atlantic Television. In that case, Chief Justice William took the rather pragmatic approach to Canadian case precedents. Chief Justice Williams said, in approaching Canadian cases, he said, "It is common knowledge that the Barbados Companies Act borrowed heavily from Canadian precedents, and I do not think it amiss to refer to the judgment of McDonald J. in the Alberta Court of Queen's Bench case of Edmonton Place, etc." Well, what you see here, which is very interesting, is that Chief Justice Williams is not attempting to find any principle basis for approaching the Canadian precedents. He says we have fashioned our legislation on Canadian Business Corporations Act, and as a matter of convenience, as a matter of pragmatism, we will look at Canadian precedents. There was no attempt to fashion the thing within the context of a theory. And if you look at the cases subsequent to that, there's the Trinidadian case of Jaikaran and Saidenku Investments Corporation. In that case, Mr. Justice of Appeal Musai, this is a case from the Trinidad and Tobago Court of Appeal. He took a similar pragmatic approach to Canadian precedents. He followed them not because he found a theory or a jurisprudential reason to, other than a pragmatic reason to follow it. And the same approach to Canadian case authority was adopted by Justice Sykes. He is now Chief Justice Sykes. In the Jamaican Supreme Court decision in Mu Young and Dewar. Now, I should add that I find that Justice Sykes perhaps is one of the leading judges in respect of the new companies legislation. But he nevertheless, in Mu Young, adopted Canadian precedents essentially on the basis that that the Jamaican Act was based on the Canadian legislative example. And in the most recent case, Bahamian case of Galantis and Alexio, which went to the Privy Council, the Privy Council upheld the approach of the courts having regard and applying the Canadian cases. But what is also noticeable is that the Privy Council did not itself attempt to provide a principal reason for adopting Canadian precedents. I must confess that I feel left out because in the work to which Suzanne referred, the Commonwealth Caribbean Company Law, I attempted to argue that there is a principal basis, and that the principal basis is that our legislatures must have intended in enacting the Canadian Business Corporations Act, must have intended the case law on that to guide in the interpretation of the act. So, in other words, I believe that the approach can be justified, perhaps on the basis of pragmatism, but in principle, it can be justified with respect to the rules governing interpretation and giving effect to the intention of Parliament. Now, all of this is not to suggest that the English case law in the region has taken a back seat and that it is no longer relevant in company law adjudication in the Commonwealth Caribbean. There are two reasons why English case law has continued to be relevant in approaching company litigation in the Commonwealth Caribbean. The first is because some provisions in the Canadian Act itself, the Canadian Business Corporation Act itself, some of the provisions in that act which have been adopted in the Commonwealth Caribbean are themselves based on English legislation. And where this is so, English case law remains persuasive authority. And the Caribbean Court of Justice in a very recent case, 2020 case of Nabi and Nabi, made that point. Another reason why English case law remains very relevant is because the body of company law is not only legislation. There are common law principles which remain within the adjudication of company law in the region. And one such area, for instance, is the area of lifting the corporate veil. And in the Jamaican Court of Appeal case of international hotels and proprietors, strata, etc., Mr. Justice Morrison, as he then was, had regard to English authorities on lifting the veil and delivered what, in my view, is one of the most comprehensive analysis of lifting the veil. I consider it to be a masterful treatment of lifting the veil. He looked into the most recent UK Supreme Court decision in Press and Petrodel, and I think that the Jamaican Court of Appeal, in the presence of Mr. Justice of Appeal Morrison, as he then was, now President Morrison, I think that did the region proud. The third aspect of adjudication in Commonwealth Caribbean courts in respect of the new legislation relates to the question of what I call an overriding concern to do justice and equity in the application of the legislation. Now, this tendency is most evident when one looks at the complainant remedies, especially of oppression. The courts in these cases attempt to make decisions which comport with the notions of justice and equity. Now, the reason why this is so important is because Suzanne made reference earlier to the contractarian model, which was the English model. That is the Section 20, which says that the articles and so on constitute a contract. And so a company law adjudication did not permit of things like justice and equity. Justice and equity was in the logic which flowed from the fact that, or the consequence that the memorandum and articles were contracts. So this is a new approach which one finds in the Commonwealth Caribbean jurisprudence. I'm aware that I don't have time to go through all of the cases or any of the cases which would illustrate this point. So you're going to have to take my word for it. I will make available my presentation to Suzanne for those of you who are interested in the area, and you'll see that there are cases, for instance, like the same Convest, there are a Mercy, there are cases like medical Five-Star Medical from Trinidad. All of these are cases where one will find the courts embracing this notion of justice and equity in company law adjudication. I would like to make the point, however, and indeed in Nabi, the Caribbean Court of Justice also invoked a section in the Guyanese Companies Act and decided the case on the question of justice and equity. I have to say to you, though, that saying that the courts have embraced the notion of justice and equity is not to suggest that has now become a wild card. It certainly is not a wild card. I think that the courts are acting very responsibly. And when you look at the cases on the complainant's remedy, you'll find that the courts are attempting to put brakes on the operation of the notion of justice and equity. Now,
Judge, I just wanted to put you on notice that you have I'll give you another 2 minutes.
That's why I just reached conclusion.
Okay.
Yes, I reached my conclusion. And the conclusion which I've arrived at in looking at the Caribbean courts in respect of new legislation is that they've been very pragmatic in approaching the challenges posed by the new legislation. Hanging on to the coattail of Canadian precedents, the courts have more than adequately, in my respectful view, met these challenges. I've not dealt with the issue of regional precedents in the courts, but that will be a discussion which I reserve for the launch of Suzanne's next book. Thank you very much.
Thank you, Judge Burgess. And next up is Mr. Justice Dennis Morrison, giving us an insight into how courts in Jamaica have treated with the rather tricky area of piercing the corporate veil. Dennis?
Thank you so much, Chairperson Celia. I feel like a bit of an imposter in this crowd because here am I, who speaks of myself still as a student of company law, seated among a panel of real experts on company law. I'm very grateful to them and to Suzanne for thinking that I might have something to contribute in this kind of environment. I want to congratulate Suzanne on what is an outstanding achievement by any measure. The work she has done on corporate business principles, as Andrew has indicated, will survive for a very long time. It's a very important study, and I hope the success which it will have will push her to more and more efforts in this area. I want to talk a little bit about the evolving jurisprudence and lifting the corporate veil, a subject on which Andrew touched a moment ago. I thank him for his kind words on a judgment of our Court of Appeal on the topic. But to some extent, it is still a journey because I think courts all over the Commonwealth and all over the common law world generally are still grappling with how to deal with this issue. The doctrine of separate legal personality dictates, of course, that a company incorporated under the Companies Act is a legal entity and as such is wholly distinct from its shareholders. Each company, therefore, has rights and liabilities of its own, which are distinct from those of its shareholders, and it has property of its own, which is not that of the shareholders. Put metaphorically, as Justice Burgess himself explains in his seminal work, Commonwealth Caribbean Company Law, on incorporation, a veil is drawn between the company's personality and that of its shareholders. And the principle applies as much to a company that is wholly owned and controlled by one man as to any other company. The doctrine is, of course, at the cornerstone of the principles of company law. And so Salomon and Salomon, the case from which it derives, is still justly celebrated as one of the truly seminal decisions in English and Commonwealth Caribbean company law. But unqualified approbation of the principle has never been universal. Indeed, for much of the 20th century, and no doubt still in certain quarters, the doctrine attracted a degree of suspicion, a feeling that it may be used as a device to conceal the nefarious intentions of business people and others to defraud, or at any rate to disadvantage ordinary mortals. Hence, as the redoubtable Lord Denning put it at the end of the 1960s, in perhaps not surprisingly a tax case, the doctrine laid down in Solomon and Solomon has to be watched very carefully. It has often been supposed to cast a veil over the personality of a limited company through which the courts cannot see. But that is not true. The courts can and often do draw aside the veil. They can and often do pull off the mask. They look to see what really lies behind. The legislature has shown the way with group companies, and the courts should follow suit. But happily, for the corporate structure anyway, that typically trenchant affirmation of the readiness of courts to pull off the mask did not survive even to the end of the last century. Indeed, it is now generally accepted that incorporation can and does serve perfectly legitimate business interests, and that it is, generally speaking, the duty of the courts to give effect to the logic of incorporation, unless there are compelling reasons of law or policy not to do so. So, for instance, in 1990, in the justly celebrated decision of the Court of Appeal of England and Wales in Adams and Cape Industries, perhaps in direct answer to Lord Denning, it was held that the Solomon principle also applied to companies within a corporate group. It is against that background that we can go directly to the leading decision of the Supreme Court of the United Kingdom in Prest and Petrodel Resources. The issue in the case was whether it was open to the court on the wife's application in matrimonial proceedings to pierce the corporate veil in relation to a number of complexly structured offshore companies, of which the husband was the sole owner. The judge at first instance had already rejected the wife's contention that the husband had been guilty of any impropriety in relation to the companies. Delivering the leading judgment in the case, Lord Sumption reaffirmed the vitality of the doctrine of separate legal personality, while at the same time drawing more closely the limits within which it was open to the court to displace the veil of incorporation. And if you will forgive me a longish quotation from Lord Sumption's judgment, I think it is important to set the stage for what will follow. I conclude, he said, that there is a limited principle of English law which applies when a person is under an existing legal obligation or liability or subject to an existing legal restriction which he deliberately evades or whose enforcement he deliberately frustrates by interposing a company under his control. The court may then pierce the corporate veil for the purpose, and only for the purpose, of depriving the company or its controller of the advantage that they would otherwise have obtained by the company's separate legal personality. The principle is properly described as a limited one, because in almost every case where the test is satisfied, the facts will in practice disclose a legal relationship between the company and its controller, which will make it unnecessary to pierce the corporate veil. If it is not necessary to pierce the corporate veil, it is not appropriate to do so, because on that footing, there is no public policy imperative which justifies that course. But the recognition of a small residual category of cases where the abuse of the corporate veil to evade, or frustrate the law can be addressed only by disregarding the legal personality. And I believe this is consistent with long-standing principles of legal policy. So the judgment recognizes this residual category of cases in which the courts preserve a power to pierce the corporate veil, but it is cast nowhere as widely as Lord Denning cast it. There is no suggestion that if the judge's view is that justice demands it, the corporate veil can be pierced. Rather, the emphasis is the opposite. The courts should strive to preserve the corporate veil where there is no relevant wrongdoing or abuse to justify piercing it. So Prest may be regarded as a further watershed in the development of modern company law. Thus, in a 2019 appeal from Mauritius, the Privy Council restated the position in what is now orthodox Prest language. The distinct legal personality of a company and the fact that its rights and liabilities are distinct from those of its shareholders are subject to very limited exceptions, fundamental principles. And most recently, in Leon against the Attorney General and others, the Court of Appeal of England and Wales, and this is a case reported in this year, 2020, considered that to attribute an interest in a lease to the beneficial owner of the company that was the actual party to the lease, in the face of a finding that the company did not hold the lease on trust for the owner, and I quote, would necessarily involve a piercing of the corporate veil, which could not be justified, having regard to the decision in Prest. The Jamaican courts have been equally unequivocal. At the level of the Court of Appeal, Suzanne notes, and Andrew has already referred to the decision in International Hotels against Proprietor Strata Plan, in which the court held that a subsidiary could and did acquire an interest against its parent company by adverse possession. And in a second case, UDC and Jassitar, in which it was held that a contract for the provision of security services with a subsidiary company did not give rise to any liability on the part of the parent company for the wrongful conduct of the guards employed to the subsidiary. So that's the position at the level of the Court of Appeal so far. Prest has also since been applied in a number of decisions at first instance. I will mention just three of them. In one of them, the first, Div Deep et al. Against Topaz Jewelry. This is a long-standing set of litigation between brothers and cousins involved in big business in the country. The issue on a strikeout application was whether the claimants could recover damages for breach of contract and fraud against the first defendant company for wrongs allegedly committed by the second defendant, who was the company's majority shareholder and managing director. Describing this as the piercing of the veil point, Ms. Justice Edwards, as she then was, observed that although there is no general principle for piercing the veil in the interest of justice, it is, however, possible by examining the cases to see a thread of principle running through them, which could give some indication of the basis upon which the court could depart from Salomon and Salomon. The judge then identified a number of principles emerging from the older cases. One example, the veil of incorporation may be pierced where the incorporation was a cloak or a sham to avoid an existing legal obligation. Another, the veil of incorporation will be pierced where the company was incorporated to conceal or evade legal or equitable obligations, or to evade a law relating to the distribution of assets, or to frustrate the enforcement of law. And then turning to Prest, the judge then discerned what she described as another broader principle, which is that the veil may be pierced to prevent an abuse of the corporate legal personality. She then gave specific examples drawn from Lord Sumption's judgment. She spoke of one, the veil may be pierced to undo a relevant impropriety or wrongdoing where no other remedy is available. Two, where it may be relevant that the wrongdoing must be linked to the use of the corporate structure to evade an existing legal obligation. And three, there was no need to pierce the veil when the facts disclose a legal relationship between the company and the controller, which makes it unnecessary to do so. And so therefore, in the case before her, the judge was able to decide the strikeout application on the basis that the relationship between the first and second defendant was a question of fact to be explored at trial, and there was therefore no basis to suggest at this stage that there should be a piercing of the veil. And indeed, it might well turn out that after trial, the actions of the first defendant could have been interpreted as the actions of the second defendant because of an agency relationship. In the second case I would mention, Menzies and Ellis and Willis, perhaps a more straightforward application of the principle. The issue was whether the owner of the vehicle involved in an accident, who was a director of the company which had control and management of the vehicle at the material time, would be held liable to the claimant for injuries sustained in an accident involving the vehicle. Applying press, Mr. Justice Fraser, as he then was, held that the company was a separate legal entity from its directors, with the result that it was only the company that had custody and control of the vehicle which could be liable for the negligence of its servants, that is, and not the owner. And finally, in the third case, which is McDonald Millingen against Margie Geddes and Bardi Limited, the first defendant, Mrs. M.G., was the widow and substantial heiress of the estate of the late Paul Geddes, one of the co-founders of Deno and Geddes Limited. And Professor Andrew Burgess and I will remember from the younger incarnation of both our lives that we once participated greatly in the products of D&G Limited. The issue in this aspect of the case was whether an attorney at law who had at some point represented Mrs. Geddes in ongoing litigation was entitled to a charging order against shares held by the second defendant, Bardi Limited, in D&G. The basis of the lawyer's claim was that Mrs. Geddes was beneficially entitled to 100% of the assets of the company, which included the D&G shares, and that Bardi Limited was therefore the alter ego of Mrs. Geddes. Sir Justice Lang refused to grant the charging order. After restating the orthodox Salomon position that a company is a separate legal entity distinct from its shareholders, Sir Justice Lang observed that the principle was not absolute, and that the courts have accepted that in appropriate cases, it may be necessary to pierce or lift the corporate veil. But next, having considered Lord Sumption's judgment in press, Mr. Justice Lang concluded that there was no justification for lifting the corporate veil in this case, and he found that the company was entitled to the usual protection afforded to a corporate entity with separate legal personality. Its assets, including the assets it holds in D&G, do not belong to Mrs. Geddes and cannot properly form the basis of a charging order over the assets of Mrs. Geddes. And I think the judge in that case placed the discussion on the basis of Lord Sumption's, I think, validating or revalidating the principle that incorporation serves legitimate purposes, and that the business people can and ought to be able to depend on the logic of incorporation in the organization of their affairs. On the basis of this limited sample, then, I think it is fair to conclude that the courts in Jamaica have so far, and several of the decisions that I have referred to are first instance decisions. Who knows what will become of them as they wend their way up the hierarchy of adjudication. But so far, the courts in Jamaica have so far amply validated Lord Sumption's restrictive characterization of the piercing of the veil principle. So for the moment, Salomon is alive and well. But I have, of course, been describing the position at common law. As is well known, subject to the constraints of the Constitution, the powers of the legislature are vast. In all parts of the world these days, some would say far more so than in others. We must be ever conscious of changing international standards in the area of financial regulation. So now, transparency is the name of the game, and that's a good thing. But already on one view, in relation to the veil of incorporation, the provisions of the Companies Amendment Act 2017 in Jamaica, which introduces new requirements for the provision of information relating to the beneficial ownership of companies, may be seen as a contradictory omen. Only time will tell. And I look forward to sharing this discussion with this panel and others as things progress. Thank you so much.
Thank you, Judge. Thank you very much, Dennis. And now over to Professor Puri, who will speak on evolving trends in director and parent company liability. Professor Puri.
Thank you so much, Dr. Blake, and delighted to be here to celebrate Dr. Goldson's book and be on a panel with such a distinguished group. You'll see that, what I'd like to speak about today for the next few minutes is indeed a little bit more on piercing the corporate veil, in particular in terms of parent company liability for the actions of subsidiaries, and also director liability. So it ties in very, very nicely with all of the comments that have been made in different ways. But most importantly, we're all here to celebrate Dr. Suzanne Goldson's new book. And Suzanne is, from my perspective, just a force of nature. She does amazing work in corporate law and corporate governance, and has such a terrific lens, a terrific critical lens, as well as an excellent kind of sense of how things work in practice. She's one of my favorite people, and I'm delighted to be here with all of you to celebrate the book and to talk about corporate law, obviously in Jamaica, in the Caribbean, and in the Commonwealth. And Justice Burgess did an excellent job, of course, of speaking about the influence of Canadian law on the development of corporate law in Jamaica and in other parts of the Caribbean. So I won't spend too much time doing that. What I would like to do is speak about parent oversight of their subsidiaries and how the law treats the parent-subsidiary relationship in terms of corporate law. Talk briefly, I actually will skip over my second point, which is the relationship between Canadian corporate law and Caribbean corporate law, because Justice Burgess has done justice to it. The move from shareholder primacy to stakeholder-focused governance, Suzanne touched on briefly, and so again, won't spend a ton of time on it, but I think these points just highlight the, kind of, even though we didn't coordinate on what we would speak about, just kind of what is important in corporate law and corporate governance right now. And then I'll speak a fair bit on parent subsidiary governance, and obviously President Morrison spoke about liability and piercing the veil, and I'll speak about some points that he didn't touch on. So first, of course, is that this governance for whom very much historically it has been a shareholder focused model in terms of the law or the interpretation of the law, even if that is not what was in the statute, as well as what kind of expectations of shareholders were. And we are seeing a move towards stakeholder-centric governance, taking into account the interests of relevant stakeholders who are affected by business decisions in an appropriate way in terms of the process of decision making by directors of organizations. So even though the wording of the legislation may be the same in terms of what is in the best interest of the corporation, courts have certainly made pronouncements that directors have an opportunity, aren't mandated, but have an opportunity and can consider the interests of relevant stakeholders. In the Canada Business Corporations Act, there's now, as of the last year, an amendment to the Act which specifically enumerates some of these stakeholders, including employees and customers and the environment. Again, it's a permissive standard, so directors can but aren't required to consider these interests, but it does change the flavor of how directors consider their duties in the boardroom, and then no doubt how judges, when reviewing actions, to the extent there's a derivative suit or an oppression claim or a claim about breach of duties, how judges kind of engage in the analytical framework. So the interesting thing, though, of course, as much as we are moving to a away from the shareholder primacy model to the stakeholder governance model in terms of the interpretation of fiduciary duties, one thing still remains the same, which is that shareholders elect the board. So directors have this broad fiduciary duty. It's being interpreted broadly. Nonetheless, it's shareholders that elect the directors. It's shareholders that can remove the directors. And yes, other stakeholders other than shareholders can commence suits. But shareholders have a preferred position, particularly in relation to the oppression remedy, where shareholders are expressly named as a complainant. Other complainants are often have to get the approval of the court. So a big difference between shareholders and other stakeholders in practice. That said, much of the push for thinking about stakeholder interests is coming from shareholders, is coming from pension funds and other significant long view shareholders who see that as adding value at the end of the day to the business organization and to society. We all know the fiduciary duties and the duty of care. I won't go through them in any detail. What I would love to talk about a little bit more is the parent-subsidiary relationship. And here I've just put one example of a Canadian parent co. Having let's say an 80% ownership in a Jamaican subsidiary. The parent company has a controlling family and it has public shareholders. The Jamaican subsidiary is not wholly owned by the parent company, but is, let's say, 80% owned, and then there are public shareholders. What happens in this context? And I thought I would, lay this out. And Justice Morrison, of course, spoke about all the legitimate reasons that one would have subsidiaries. There could be, requirements in a certain jurisdiction to have a local corporation. There could be tax reasons. There could be kind of ring fencing liability, legitimate liability reasons as well. And so thought I would use this as an example to discuss some of the relevant issues. Now, Justice Burgess already spoke about the interconnectedness of Canadian and Jamaican corporate law and the use of precedent, principled or practical. So I won't go into that, but our legislative provisions are very similar. And I highlighted one change in the Canada Business Corporations Act in terms of the enumeration of the specific stakeholder groups, which is new for us. Now, so in terms of, one of the key issues, the parent company's board of directors, they owe a fiduciary duty of care. The fiduciary duty is to the corporation. We know that. That is how, indeed, the Canadian courts, including the Canadian Supreme Court, has interpreted the best interests of the corporation. It's not to the shareholders, not to any particular stakeholder, including not to a group of creditors when the company is on the brink of insolvency. The end result is that directors who have been elected by the shareholders have a big responsibility and have a lot of discretion to determine what to do when making significant decisions on behalf of the corporation and making decisions where some shareholders will be happy and some will be unhappy with the outcome. And so, I think that goes to another conversation that we can certainly have about who the directors are and their experience and background so that they bring all that to bear to the table. But that's a separate discussion, I think, which we could have a whole panel on. Let me turn to the next slide, which is then going to the issue of, how much. So you've got a parent company. What about shareholders. You've got a controlling family and you've got public shareholders. How much can the parent company directors, how much kind of leeway do they have in thinking about the majority shareholder, the minority, or the public shareholders? And Canadian law is interesting. There's only one case, one significant case, and it's from many decades ago, where the parent company with a company's directors went against the interests of the controlling family or the controlling shareholder, and in that case, the court said that's fine. They said the directors did not breach their fiduciary duty because their role was to think about the best interests of the corporation. And yes, the controlling group's interests got diluted, but there was good reason to issue shares to this other entity because they were thinking about how to, in this case, it was the mining company, how to advance and develop the mine. And so that's only one case where the directors went against the controlling family. In all of the other cases, courts have held that if the board is constrained by the controlling family or the controlling group's views on a particular transaction or a particular event, then the board can take that into account in making their decision. So if the controlling family would have to sign off on a certain transaction in terms of vote in favor of it, and the controlling family has made it clear that they are not going to because they're not in favor of that particular acquirer or that particular bidder because of their bad history of labor relations or their weak financial position in their view, then the board of the company, knowing this, can reasonably be kind of constrain their decision making to say the parent is not going to sign off or the controlling family is not going to sign off. So I think relevant to the analysis for board directors. Now, let me turn to the next kind of question I have here is, so you've got a Canadian parent co and you've got a subsidiary. How much oversight can and should the parent co be exercising over the subsidiary? Now, I think about this from kind of the business perspective, and then I think about what the law has to say. And from the business perspective, you've an organization has, spent hundreds of thousands of dollars, millions of dollars to create a subsidiary, to create a kind of whether it's a line of business or expand into a certain jurisdiction or to make an acquisition. So from a business level, you're doing this because you see value in the larger enterprise, you see value in the integration, you see value in kind of operational integration and in having one enterprise, globally or otherwise. Now, from a legal perspective, of course, as we know from the cases that we've spoken about, at some point, if the parent exercises too much control, such control that the subsidiary is a mere puppet, and obviously some of the case law speaks to fraud as well, but to the extent that the parent company exercises such a level of control that the subsidiary has no kind of life of its own, then you have the concern and the public policy issue of, well, then the parent company should be responsible for the subsidiary's actions and for any harm that the subsidiary causes to other shareholders or other stakeholders. And so it's an interesting dilemma. I mean, from a business perspective, you want to, as a parent company, make sure that your investment, your oversight is strong and significant and that you're providing appropriate direction. But on the other hand, you don't want to provide too much so that the law says, well, you've just taken over. And so I would love to hear any kind of comments or feedback that others on the panel or other attendees have on this point, because I think it's an important kind of governance issue. And you might have kind of business thinking one way, but then law perhaps being in another spot. And I think it's important to bring everything together. Now, does parent co-owe a duty of care to the subsidiaries, stakeholders? And so from the fiduciary, so we're seeing a number of cases, of course, that I know are of interest to a lot, where you've got groups that have been harmed by the subsidiary, whether it's, or feel that they've been harmed, whether it's minority shareholders or whether it's other stakeholders, so local community or suppliers or customers. The subsidiary, let's say, has very little cash in its accounts, and so those who have been harmed or claim they've been harmed will look to others with deeper pockets, and so we'll look to the parent. And we're seeing, of course, a number of cases around the world, but in particular in Canada and in the UK, where claims are being made by plaintiffs or groups of plaintiffs saying that the parent company owed a duty of care in tort law to us because of their active involvement and control over issues that the subsidiary was or should have been dealing with on its own. And so, in the Canadian context, the courts have said we're willing to listen. There may be a duty of care, but you're not, the defendants are not going to be able to strike out or have the action thrown out of the courts at this early stage, because if the facts at trial suggest that there was significant involvement by the parent and significant involvement crossing a certain line, then there may be a case under tort law for holding the parent company responsible. It's interesting that many of the groups, the plaintiff groups, are bypassing corporate law. They're not even in many cases attempting to pierce the corporate veil because of the high standard in our precedents for piercing the veil. And of course, we can discuss that further as well. But this is an interesting development. In Canadian courts, we don't have any cases that I can refer you to where tort liability, this duty of care, has been found. But there are a number of cases that are making their way through the Canadian courts on the basis that judges are willing to listen to these arguments. And interestingly, two of the cases, one last year, one just in the last few weeks, have settled. So of course, as we know, most cases settle, and cases settle based on the different, senses of what's going to happen when they do proceed to trial. And the Nevson case, which some of you may have been following, that settled for an undisclosed amount, and obviously we won't therefore have a decision on the facts. And as well, Tahoe Resources, when Pan American Silver bought Tahoe Resources last year, soon thereafter they settled the case so that they could reopen the mine and start to reestablish good relations with the local community and move forward from a business perspective. So again, we're going to not have a decision based on the facts of that case either, which at one level, of course, is to legal scholars like us is unfortunate. At another level, you can appreciate why parties will and should settle to move forward. So my next slide, the question I asked there is, does any of our kind of analysis change if either parent co or sub co are in financial distress? And I think the duty of the fiduciary duty, the duty of care themselves don't change. But I think what happens, of course, is that the interests of a parent company and the interests of a subsidiary company may, in some circumstances, be different when you've got different groups of stakeholders that you have to think about, and when one or both are in financial distress. And so important for us to keep in mind as well. And so, of course, so much of this analysis here becomes so fact specific. It's hard to draw kind of or lay out principles that we can apply in all contexts. It very much depends on the facts of a particular case. Now, this, of course, is the interesting issue, or one of the key issues, is how does the subsidiary, and in particular the subsidiary's directors, how should they be considering the interests of the parent company? You've got kind of a enterprise-wide strategy. You've got perhaps the parent company helping the subsidiary financially in many cases. How should the subsidiary be considering the parent's interests? And when I highlighted the case law earlier about the controlling family or the controlling shareholder group, being able to take that into account, I think that is still relevant here. I mean, it does depend in many ways on how much shareholding and how much voting power the parent company has. But I think equally so, I think the subsidiary's board needs to make sure that it carefully considers the interests of the public shareholders, the minority shareholders if there are, and the interests of the relevant stakeholders to make sure that they're being treated fairly and that their interests are being considered and kind of relevant harm to the extent that there might be is being mitigated. And so whether it's looking at the contracts with the relevant stakeholder groups or looking at what would be fair and reasonable to do under the circumstances, I think is important, of course. We could speak a lot, of course, about the mirror boards and shadow directors, which of course has been alluded to, and I will not spend a ton of time on that, but I think it's quite important to for the board of the subsidiary to pay particular attention to public shareholders or minority public shareholders if there are, especially to avoid concerns about oppression, to avoid concerns that their interests were not considered appropriately. I think the situation can be simpler if there are no other shareholders, if it's a wholly owned subsidiary. That said, there are other relevant stakeholders like the government, the local government, in terms of tax revenues, in terms of regulation, and local creditors and local customers and employees who need to be thought of as well when the subsidiary is making important decisions. Again, I've highlighted the issue that the parent company could potentially be responsible to a subsidiary's stakeholders, depending on the facts of the particular case. And obviously, we've got many cases going through the Canadian courts right now, and I'm watching them with interest, and I have no doubt others are as well. So piercing the corporate veil, I've seen it continues to be used, but not in some of the significant cases of physical harm that is being complained about. And then tort law seems to be a new or a relatively new avenue that may or may not be successful, but certainly has not been shut down yet. Now, in terms of parent company liability, a couple of points that I'll highlight, and then I'll pass it back to Dr. Blake. How much direction and oversight is the parent company exercising? How much should it be exercising? And so at some level, you do expect that the parent company is going to be making key decisions, but you also want the subsidiary company board to be thinking through those key decisions from their perspective and their lens as well. You want to think, I think, in terms of this area, want to also think about how subsidiary directors are selected, who they are, how much overlap there is, and can everyone keep their respective roles separate, because it is important to do that given the separate duties. How much independence does the subsidiary have in terms of decision making? Where are decisions made? And from a business level, you do want alignment with the parent strategies. It would be rather odd if you had a subsidiary that was kind of a runaway subsidiary doing its own thing without any parent oversight or parent direction in that context. And then, I think another piece is looking at the subsidiaries' governance processes. How are directors nominated? Where are business objectives established? What sort of financial support is provided? And what the ownership level of the subsidiary is. So let me turn now to my last few points. Both the parent and the subsidiary, based on the case law, and the statutes, owe a fiduciary duty of care to the respective companies. There is clearly a move away from shareholder primacy to stakeholder governance as well, though in practice, of course, it's very complicated and nuanced because it is not a requirement that directors, consider the relevant stakeholder interests. It's permissive. That said, we know, of course, it's also good business. It is possible, of course, that the subsidiaries' directors may be held liable for unreasonably favoring the interests of a parent co in certain circumstances, and in many other circumstances. I think it is important, and the law should permit and does permit the parent company to direct and to constrain the decision-making of the subsidiary. We're also seeing that, the parent company may be held liable for the actions of the subsidiary in certain circumstances, whether in corporate law veil piercing or in tort law, and more, of course, will come in the coming years on this. And to Justice Morrison's point that it may come through the courts or it may come through legislation, because there are various ways forward here. And then I think the last point that I'll share on this is that effective governance, I think, can mitigate the risk of liability for both the parent co and the subco and the directors. And, I highlight on the next slide here, some of the good governance practices that I think are relevant in this area. And these are some of the good governance practices that courts look to when, applying the business judgment rule and saying, we're going to defer to the elected directors who are experts here. They were elected, they've got expertise, they followed good process, and therefore we don't need to step in the same way that we might if there were a conflict or if good process weren't followed. And so I've highlighted a number of considerations that really I extract from the case law in a number of jurisdictions. So independent committees, shareholder approval, majority of the minority approval, which is required by some securities statutes, how stakeholders' interests were considered, and documentation of the same, which is point 8, and then kind of independent fairness valuations and independent legal advice also where appropriate. And I don't put this list down as a kind of check the box exercise. I put this list down as taking kind of thinking carefully about what might be needed to be able to show a court or a regulator or those stakeholders who are unhappy with a significant decision that even though you're unhappy, this is what was best for the corporation. So with that, why don't I end and pass it over to Dr. Blake.
Thank you. Thank you so much, Professor. I mean, such a plate full in the short period of time that you have had. And thanks so much for reminding us that, there is still the possibility of parent company liability for the acts of their subsidiary companies, notwithstanding the judicial assertion of separate legal personality that Justice Morrison spoke about. And also for, reminding us about that slippery slope in relation to directors' liability for the, acts done by the subsidiary company, or certainly directors involved in parent company, subsidiary company circumstances. I'm going to move right into the questions, and I'm going to take this question from Jeffrey Foreman, because it has come very, very early in the presentations. It is for Justice Burgess, and Jeffrey wants to know, are there instances where courts have considered competing interpretations of similar company law provisions from different Commonwealth courts? And if that is so, how have Caribbean courts navigated those waters? Judge Burgess?
Yes, thank you very much. Very interesting question. There is one case which I can think about. This is the Jamaican case of Muyong, a judgment of Justice Sykes. I must say that if you look at the judgment, the length of the judgment is somewhat foreboding, several hundred paragraphs, but an excellent exploration of competing interpretations of one provision in the Jamaican Act. He looked at Singaporean approach, which was different from the Canadian approach, and the section which he was interpreting was also present in the Australian Companies Act. And what I thought of the judgment is that he navigated the various approaches very deftly, and in the end, he said that he had to give effect to the intention of the Jamaican Parliament, and so he came down. The way in which he resolved it is by imposing his own interpretation on the section. But that's a very good question, and I think it gives me the opportunity to say that what I find is that the Caribbean judges are not daunted by differences which may exist in the various precedents with which they have to deal. But Mr. Justice Sykes, I think, in that case, distinguished himself as a good company judge.
I don't know, our audience seems to be a bit shy, so I'm waiting on some more questions, but in the meantime, Suzanne, there are some congratulatory messages for you. Anisha Welch, congratulations, Dr. Ffolkes Goldson, on another milestone achievement. This is an awesome and much needed contribution to the literature on corporate governance. Excellent job. Caroline Hay, very interesting, Suzanne, proud of your contribution to corporate governance. Honored to have worked with you on corporate governance framework for Jamaica, and continued best wishes on your journey. Bradley Mafood says, hearty congratulations, Suzanne. Such an incredible achievement. And Lisa Cousins, congratulations, Suzanne. Keep up the good work. A very proud moment indeed. Anne-Marie Stewart says, this is yet another amazing contribution from Mrs. Goldson, and I am so proud to have been taught by her. Congratulations again. Suzanne, I don't know if you just have any responses for those persons who are congratulating you.
Well, the check will is in the mail, so thank you so much. And you know the mail is slow because it's COVID, but thank you so much. Celia, if I can take a moment to just put you on the spot and ask you if you wish to ask, for example, Professor Puri about her views on insolvency. And
maybe I could take that in another forum, but I do have a question actually for Professor Puri, and also I think, Suzanne, that I would like you to weigh in on this, and if Justice Burgess would weigh in on this, I'd be happy. Of course, we welcome the complainant's remedies provisions in our reform statutes. And of course, that clearly supports the stakeholder approach, Suzanne, that you spoke about. But do you think that it has the propensity to get a little bit unwieldy, given, of course, that whole gamut, the oppression, the unfair disregard, the unfair, what's the other one, Suzanne? Unfair disregard and unfair
prejudice and
prejudice, as well as the fact that there is so much discretion in the courts in terms of the remedies that they can grant, and also that rather problematic area certainly in some jurisdictions about who may bring an action. Don't you just think this just gets a little bit unwieldy? I'd like to hear some comments on that.
I'm happy to go first, if that makes sense, Dr. Blake.
Thank you.
Okay, so I'll share with you in terms of the oppression remedy. I did a study a few years ago, and I looked at a number of years of oppression cases in the Canadian courts, because I had the same kind of hypothesis as to, this is so broad and open-ended, and the complainants can be not just shareholders, but any of these stakeholder groups. So how have the courts been dealing with this? And so interestingly, on the complainant front, the majority of cases in Canada, and we looked at 80 cases over a period of almost 10 years, I think, almost all of the complainants were shareholders. Shareholders, either minority shareholders or 50-50 shareholders. They were also, the majority of cases dealt with private companies rather than public companies. And interestingly, where, a customer, creditor, employee. There were three types of stakeholders that tried to get complainant status, and creditors were the most likely to get complainant status. So judges, in kind of exercising their discretion, were most likely to give creditors, less likely to give consumers and employees complainant status. So, and there weren't that many cases, under 10, from what I remember, and I didn't reread the study for the purpose of our conversation today. So I think part of the analysis that judges are going through, at least in the Canadian context, when determining whether to, grant discretionary complainant status is, what other options does this stakeholder have? If we say no to moving forward with the oppression remedy, can they pursue a claim, kind of a civil claim under a contract? Either written or implied? Do they have the benefit of Consumer Protection Act legislation that they can use? Is there a regulator they can complain to? That's my thinking on that. It hasn't always been articulated that way, but I think that's part of the, kind of the principled or the conceptual framework in terms of, should they be using the oppression remedy, or is this a last resort remedy for them in this context? And then, in terms of, even though it's broad and open-ended, so apart from the complainant issue, and even though the legislation would allow public companies, private companies, sophisticated shareholders, vulnerable shareholders, it seems like it's largely being used for private companies and for minority shareholders, as opposed to now, public company shareholders are using the oppression remedy when, perhaps all they need to do is just go sell their shares on the open market. So somehow, in good form, our judiciary has kind of figured out a way so that this is not unwieldy. But I'd obviously welcome others' thoughts on, what might be expected in your context.
Yeah, Judge Burgess, I see you chomping out the bits there, waiting to weigh in on this.
Well, actually. It's a very good question. I have to say that from my study of the cases so far in the Commonwealth Caribbean, the bulk of our common company law litigation has been in the area of the oppression remedy. I think that has liberated a certain class of persons, shareholders, and so on, that never existed before. As to whether the category is unwieldy and it threatens to get out of hand, I think that early in Trinidad, in a case called 5 Medical, yes, that's right. I think that the court went off the rails. I think I see it, you know the case, and the case is a case where you had a contractual relationship between the telephone company in Trinidad and this person to whom this company, to which TL Trinidad Telephone Limited was supplying a service. The company sued. There was a clear breach of contract. There was the impression of a breach of contract, which should really have been the action that would be brought, because it was a contractual relationship between the parties. Rather surprisingly, I don't know who advised the company to bring a complainant remedy, claiming that it cost the company a lot of financial distress, and as a result, there was oppression. Now, the amazing thing is that Justice Ventor, who was the judge hearing the case, actually held that the company could bring a complainant remedy for oppression. Now, everyone knows that cannot be right. That the intention of Parliament was not to supplant the contractual remedy by a complainant's remedy, and that because you're dealing with a company which has caused you financial distress, that means that there's oppression. So I think that apart from the 5-star, the medical 5-star decision, that by and large, certainly in the Commonwealth Caribbean, that the courts have attempted to, yes, exercise just and equitable considerations, but at the same time to impose certain constraints on that, the use of that mechanism of justice and equity. So I am not as, it seems to me that you are somewhat not optimistic about what will happen with because of the breadth of the remedy, that you think that there's danger for the courts misusing or abusing the provision. I don't think that is happening from the way in which the courts have in the main been approaching the complainant remedy. I think that they recognize, yes, there are cases where the proper person, part of the definition, has a position, should have standing before the court. But I think that by and large, the courts are taking a restrained and restricted approach to the provision. Apart from the medical 5-star, I cannot think of any other case which has fallen off the rails as much as that case has.
All right, Suzanne, did you have a comment just before I take?
I sure do. Well, yes, I agree with Justice Burgess on this point, but I wanted to add a few things. I wanted to add that certainly for Jamaica, we can't fall off the rails too far because we have restricted the complainants, and this was intentional. We discussed it, and I felt that this was not appropriate for to embracing the stakeholder theory that we should limit the complainants, but we have. Although there's a mismatch, the victims, we include creditors, but a complainant can't be a creditor. That's another story. But also to Justice Burgess's point about how the cases have been dealt with in the Commonwealth Caribbean, I think there's also a correction going on. At some point, apart from the 5-star case, there seemed to have been a move to grant a remedy to persons who are not in the victim class. And I think that's a problem. So you have a proper person, but are they really a proper person if it doesn't match with the victim? And they were granted remedies. But there's a correction I see going on, and there's a move to a correction. The last point I'll make on that is that there's also a limitation on oppression. You can't just say, I'm oppressed, the action was harsh, burdensome, wrongful, and all of that. You have to show that you had a legitimate expectation a la UK or a reasonable expectation a la Canadian law. And I find, though, that our judges have used both in the same judgment, legitimate, reasonable expectation, or sometimes I use legitimate expectation, sometimes I use reasonable expectation, and reasonable expectation is there's a discrete description definition in the BCE case, Professor Puri, if you recall, and in the UK cases, O'Neill and Phillips and so on, you get this concept of legitimate expectation. But that said, that is also limits the abuse, the possibility of any abuse or use of the oppression remedy.
Thank you. There's a question here. The person has not identified him or herself, but it is for Professor Puri. Are there Canadian cases which suggest that, in your example, a director of a Jamaican subsidiary who is nominated by its Canadian parent and is an employee of the Canadian parent is at greater risk for conflicting of duties owed to the Jamaican entity?
Thank you for that question. I can't think of a particular case that I can refer you to right now, but I think the principle is indeed there, which is that, yes, I think a director who sits on the board of both a parent company and a subsidiary, or who is an employee of the parent and who sits on the subsidiary board, needs to think carefully and prudently about what kind of good process should involve where there might be a perceived conflict between the parent's interests and others' interests, whether minority shareholders or other stakeholders. So I think just good governance practices need to be implemented, and different practices for different organizations and different industries, and depending on the nature of the decision. So I think the short answer is attention should be paid to that issue, and that's where I'll stop there.
Okay, and maybe Professor Puri, you can respond to this as well, maybe as Mr. Justice Dennis Morrison. Can a director, and this is from Marina St. Rose in St. Lucia, can a director acting in good faith be held liable for torts committed by the company? Okay, so I think there's different ways to think about this, and I won't give an answer that will be perfect by any means, but it ties back with Justice Morrison's comments about legislation. I can think of many examples in terms of environmental legislation, tax legislation. So it's not tort, but it's legislative liability on directors where they were acting in good faith, but the legislature, from a policy perspective, has said no. Doesn't matter that you thought you were doing what was right for the company. You are personally responsible for, employee back wages because you were running the company on when you couldn't make payroll, or you're responsible for, for source deductions because the company didn't make them, or you're responsible for the environmental liability because you weren't. You might have been acting in good faith, but this is not the decision you should have made. In terms of common law, tort law, I think the response is more complicated, and I wouldn't want to give a clear answer without kind of thinking it through. But I think it's more complicated. I think if you're acting in good faith and the company is sued successfully in tort law, you may not be personally responsible just for that, just on that basis. I think there might need to be an independent tort that the director commits, but I'd love to speak offline about that further. Dennis, do you want to make a comment?
I would generally agree with that. We have a number of statutes as well that impose personal liability on directors. Not a huge number, but particularly in areas of tax and some aspects of financial regulation. And I suppose it's a way of ensuring that directors take their duties as directors very, very seriously. We've been trying to move from a culture whereby directorships traditionally were kudos, feathers in people's caps, and into an area where directors are still volunteer directors by and large, but far greater duties are expected of them, and it is mainly in those areas where liability might attach to them. Like Professor Puri, I wouldn't really want to generalize on what might be the situation apart from statute.
All right, so Suzanne, some more congratulatory messages for you from Camille Facey. And Suzanne, I think you need to speak about where the book may be available, but before you do that, I will just go through some more congratulatory messages for you. Marlene Parker, very valuable contribution to the discourse on evolution of corporate law in Jamaica and the region. Shireen Golding Campbell, congratulations to you. She's just bought your book, and of course she says she will enjoy reading it, and thanks very much to the panelists. Excellent presentation, Gritty Mac says, for Dr. Puri. Thank you so much, Mrs. Ffolkes Goldson. Thank you as well for your contribution to strengthening corporate governance and our knowledge on that topic, that subject. And R. Nelson, excellent presentations, and that he loves you dearly.
Celia, I every now and then take a glance at the chat, and you omitted the one that someone said, and Justice Burgess in the flesh.
Not quite, but yes, I understand.
For a long time, and we have virtually.
Not right. Yes, Suzanne, if you have any comments before I give the wrap up, Suzanne?
Oh, I just wanted to say that we could chat all day. Someone mentioned about enjoyable reading. I'm not sure about that. But certainly, hopefully, it will be useful. And of course, because cases are forever, changing things, there are new cases, there's evolving law. Even Professor Puri's comment about the CBCA, including a list of stakeholders, for example, as the UK had. The UK was lagging for a while until 2006, and then they said, wait a minute, the rest of the Commonwealth is going here, and they had the list. And even to see that list, although the precursor to that list is found in the case law in Canada, the Supreme Court of Canada, where they said companies ought to be good corporate citizens. And so, you see this evolving, and it puts a pressure on me now to get out further publication. Justice Dennis Morrison, Justice Andrew Burgess, they mentioned cases that have come about in the last couple of years. And I'm embarrassed to say, I had to get the book out before COVID, whatever. And now we have more case law. It's very exciting. Yes. But there we have it. And I'm grateful for all the assistants. I'm grateful for our admin staff and, of course, our technical team. So thank you. And thank you, Celia, for manning this in your usual expert way.
Thank you.
In your really great manner in fielding the questions. Thank you again.
Thanks, Suzanne. And it really remains for me to thank our panelists for the time that they have devoted to our symposium, for kind of deepening our insight into the judicial mind, and for casting light on various thorny issues in company law. Thank you for your contributions and for joining with us as we acknowledge and mark and celebrate Suzanne's accomplishment. And as I encourage our participants to read Suzanne's book, Corporate Business Principles, A Guide to the Jamaica Companies Act, I wish to thank you for listening and for keenly participating in the question and answer section. Before I go, I should remind you to complete the evaluation form before the end of the conference. And of course, please join us in the symposium tomorrow at 9:30. And just before you go, I think our Dean, Dr. Shazida Ali, would like to say a few words. From me, it's bye-bye.
Thank you, Celia. Now, I just wanted to publicly congratulate Suzanne on the launch of her book. I know it will be an excellent contribution to the development of the jurisprudence in the field of corporate law in the Caribbean. So I've personally congratulated her, but I wanted to publicly do so. Suzanne taught me equity just a couple of years ago. And now I have the privilege of working with her. And of course, I want to thank the panelists, Justice Burgess, who was my dean when I first started here in the faculty, Justice Morrison, who taught me and has remained my mentor. And nice to meet you too, Professor Puri. So I just wanted to add my personal thank yous, and thank you to Celia for your sharing of the session.
All right.
Until tomorrow, everyone. Bye for now.
Right.